the sky has a smile on his face, and he's shining a salute to the American race. Oh boy, it's swell to say.
Oh no, Stan Smith's intro wasn't complete. Just like the Bill of Rights without the First Amendment. Let's explore this. The First Amendment, the cornerstone of our freedoms, yet continuously reinterpreted to meet the needs of modern society. Let's dive deeper into how this amendment, though unchanged, has been adjusted to fit today's world. But what exactly is the First Amendment? In the original words of our founders, the First Amendment states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Due to our job being only to research certain parts of the First Amendment, our presentation will address the freedom of speech and expression, as well as topics related to such as obscenity and defamation. Why exactly does the First Amendment exist? American colonists and Europeans experienced much persecution for their religious beliefs, leading to many people from Europe immigrating to North America so that they could freely practice their religion. The Amish and the Pilgrims are two such examples of groups escaping their religious persecution of Europe. The British government also heavily censored Americans, using acts like the Stamp Act of 1765 to control the spread of information, in a process also known as prior restraint. More on that later. With such a history of governments holding speech hostage, the American state governments and our forefathers in 1788 wanted to protect our rights against a strong central government in the event that said government turns tyrannical, and so they included the freedom of speech in the famous Bill of Rights as they ratified the Constitution. On May 1st, 2024, a Colorado man named Daniel Larson was arrested on 7 counts of domestic terrorism. Why, you ask? Continuous verbal threats against federal buildings and employees, though he never followed through. The trial hasn't started yet, but it begs the question: does his constitutional right to free speech apply here? Does free speech not mean you can say whatever you want? Let's take a stroll down the legal lane with some key Supreme Court decisions. In 1964, the landmark case New York Times Company v. Sullivan redefined defamation law. The New York Times published an ad to raise funds for Martin Luther King's defense, which contained several inaccuracies. Montgomery Public Safety Commissioner L.B. Sullivan sued for defamation, initially winning $500,000 in damages. The Supreme Court reversed the decision, ruling that the public officials must prove actual malice. That is, the publisher knew the information was false or acted with reckless disregard for the truth. This decision set a high bar for defamation claims involving public figures. So no, you can't just say whatever you want. This case is considered a landmark case as it is an example of how the First Amendment adapting to a changing world. The case created the actual malice standard, defined as with knowledge that the speech/media in question was false or with reckless disregard of whether it was false or not. The actual malice standard permanently changed the rights of public figures. From this point on, public officials or public figures were not allowed to sue for defamation unless the speech fell under the actual malice standard. An example of this can be seen in Times Inc. v. Firestone. The Time magazine reported that the divorce of a wealthy couple, Russell and Mary Firestone, was due to extreme cruelty and adultery. Mary Firestone sued for defamation after the Florida court finalized the divorce without grounds. The Florida courts also failed to provide a distinct determination of fault. The Supreme Court decided that the Time did not have its First Amendment rights violated in the defamation lawsuit, and held that the actual malice standard does not automatically apply to private individuals, even if they are involved in public controversies, unless the plaintiff is clearly established as a public figure. In other words, just because Firestone was involved in a public controversy, they were still protected from old defaming speech, as opposed to a public figure who would not be protected. Another defamation case was McDonald v. Smith, which involved a bitter dispute over a U.S. attorney appointment. Smith alleged that McDonald sent defamatory letters to President Reagan, preventing his appointment. The Constitution ruled against him, citing his position as a public official and a lack of actual malice as being preventative of his ability to sue for defamation. As you can see, in the situation of public officials, defamation is only prosecutable if the defamation is deemed to involve actual malice. The Supreme Court has upheld this standard, further showing how the First Amendment and its protections have continued. Air Wisconsin Airlines Corps v. Hooper involved a pilot named Hooper reported to the TSA as potentially armed disgruntled after failing certification tests. Due to Hooper's position, he was legally allowed to carry a firearm as a pilot, but not as a passenger. After being detained on the aircraft as a passenger, the pilot sued for defamation. The Supreme Court ruled against Hooper, reinforcing that reports made to TSA were protected as long as they were reasonable and not grossly inaccurate, upholding the standard for defamation. So while the First Amendment remains unchanged, its restrictions evolve. Our freedoms are protected, but not without limits. And so, if you ever find yourself in a pickle, remember that defamation can be defamation in a lot of different situations. But it's always defamation, no matter who you are speaking to about, if your speech includes gross or reckless disregard of whether what you're saying is true or not.
But what about obscenity? In what other cases can the federal government censor your speech? In John Cleland's Memoirs of a Woman of Pleasure v. Attorney General of Massachusetts, the Supreme Court addressed the issue of obscenity. Massachusetts had declared the book, also known as Fanny Hill, obscene and banned its sale. The court ruled that for material to be considered obscene, it must be utterly without redeeming social value. This decision set the standard of obscenity, adjusting our First Amendment to an ever industrializing world and setting the stage for the new America. For example, in 1999, in a case called Barnes v. Glenn Theater, Glenn Theater and the Kitty Cat Lounge were challenged Indiana's public indecency law, which required dancers to wear minimal clothing. They argue that nude dancing is a form of expressive conduct protected by the First Amendment. The Supreme Court acknowledged nude dancing as expressive conduct, but upheld the statute, stating that public indecency laws are justified despite their limitations on expressive activity. Nudity in the situations like the ones the dancers found themselves in were without social value, and so this act showed a continuation of the First Amendment restricting obscenity. In this case also established that some forms of expression have strict limitations. But Americans have also challenged this definition of obscenity, like in Ashcroft v. Free Speech Coalition, where the Supreme Court examined the Child Pornography Prevention Act, CPPA, of 1996.
It sure is hard being a Supreme Court justice. I wonder what case is up next. What is this? We think an act banning child porn is unconstitutional?
The court struck down the CPPA, ruling it overbroad and vague, emphasizing that restrictions on the First Amendment rights must be clear and narrowly defined. This showed a readjustment to a new world using old rhetoric. The states responsible for our Constitution's ratification never foresaw the level of connection our world would reach, and our new mediums of connection, and so our changing world calls for the continuous readjustment of how the First Amendment applies, as shown by Ashcroft v. Free Speech Coalition. The decision to label terms like appears to be from previous legislation unconstitutional in the context of speech proves this. But what if someone combines media which would be labeled obscene with political statements? Our very own teacher, Mr. Marino, knows the answer to this. From Giles v. Marino. Giles v. Marino involved a student wearing a political shirt with controversial imagery, including alcohol and language critical of George Bush. The student was suspended, leading to a lawsuit claiming a violation of the First Amendment. The Supreme Court sided with the student, stating that the political message on the shirt was protected speech and could not be censored without infringing on constitutional rights. The imagery on the shirt was deemed critical to the statement being made, and therefore, though on its own the imagery may be considered obscene, when paired with a political statement it becomes protected. But what if someone forced you to submit anything you wanted to say publicly for review, like the British did with Stamp Act of 1765, essentially censoring you? Does our freedom of speech protect us in this situation? Enter Ferris Alexander, the porn king of Minnesota, who was convicted of distributing obscene materials and violating RICO laws in a case known as Alexander v. United States. He argued that the forfeiture of his adult entertainment business amounted to prior restraint. Prior restraint is the process of a government or institution reviewing the context of broadcastable media or speech so that they can potentially suppress it on the grounds that the material is harmful or defaming. Established in 1931 in a case known as Near v. Minnesota, this essentially is the process of someone forcing you to submit your beliefs for review so that your belief can be controlled. The First Amendment severely limits the federal government from doing such a thing. The Supreme Court disagreed that the forfeiture of a business constituted prior restraint, ruling that forfeiture of assets obtained through illegal activities does not constitute prior restraint or violate the First Amendment. Further, the federal government wouldn't be restricting his ability to distribute obscene materials after he finished his sentence, and therefore there was no prior restraint on his future activities. Those involved in the ratification of the Constitution tried to patch up every hole in the First Amendment that they could to prevent someone from taking advantage of it. However, as times change, our country experiences evolution that our forefathers could never have foreseen, and so the First Amendment continues to adapt while the goal behind it remains the same. The Supreme Court has maintained that illicit activities are not protected by the First Amendment, as discussed in Alexander v. United States, but what about third parties using illegally obtained speech? In Bartnicki v. Vopper, a radio station aired an illegally intercepted conversation between union officials discussing negotiations with a local school board. The union sued, claiming the broadcast violated their privacy. The Supreme Court ruled that the First Amendment protects the disclosure of illegally obtained communications if the broadcaster did not participate in the illegal interception, balancing privacy concerns with freedom of speech/press. So the only situation where someone is allowed to censor you for obscene expression or speech is if it's deemed to be utterly without redeeming social value. Obscenity has continuously readjusted to fit our changing world and to make sure that the First Amendment applies to new situations in the way it was intended to apply to old situations, like with Barnes v. Glenn Theater. So while the First Amendment remains unchanged, its interpretation evolves. Our freedoms are protected but not without limits. And that's the ongoing journey of the First Amendment, balancing freedom and responsibility. Until next time.